one of the things that we're hoping to promote in the course of the Anatomy of a Commission project. Similarly, and I think this is where there's a lot of opportunity for innovation, when a work might incorporate underlying rights from a text, from a poem, from somebody, a third party right that from which the work is being adapted or developed, how do we, again, put that on the table on the front end of the process to say, how are we going to work together to acquire the textual rights, poetry rights, adaptation rights, story making rights? This is where Hollywood, I think, is really forward thinking and saying there are lots and lots of amazing stories to be told and shared and developed. How can we bring some of those stories and material into the concert environment in a way that allows for the rights holder to be recognized and compensated, but also allows the composer to feel like they're not sort of the victim of copyright and can actually engage in an innovative process, and the commissioner as well, right? There may be something in the community or someone in the community with whom the organization and the composer all want to collaborate with. This is the space to really have that conversation. And maybe it's dramatic, maybe it's non-dramatic. This discussion guide was written primarily for a non-dramatic context. In other words, not for opera or not for staging, but that's not to say that it couldn't be developed, for those uses as well. So I think this is where there's a lot of hidden and unlocked opportunity for the, concert performing arts world to embrace the engagement with third-party underlying rights as a means of developing new works for the concert stage. And I hope it takes shape as part of this process. Another part of our discussion guide that I think is particularly interesting and important is for composer and commissioner to be keying into the grant of rights, because that's really kind of that's the core of where this all comes down to, what rights are being granted. And more often than not, what's being granted is essentially a contract right, essentially who gets to present the world premiere performance or performances of this particular work at the exclusion contractually, right, of everybody else. And so that is dictated by contract, and then who may be able to present or premiere subsequent performances, regional performances, and then for how long might this exclusivity period operate if a particular ensemble has exclusivity for a work over a certain amount of time. What is the length of that exclusivity period, and why might an ensemble want exclusivity? Well, it may be because they want to take the work on tour, and they want to be the only ones who perform it, or they want the opportunity to record the work commercially. So there are a number of reasons why exclusivity may be beneficial, and the question is sort of how is that, of course, factored into some of the other compensation terms. So the grant of rights section, becomes a very important part of the agreement, and that's functionally what gives the organization the value at the end of the day. What I often see and could see here is not only a grant of rights regarding the initial performance, but even if the commissioning ensemble is going to have the right to perform the work in subsequent years without having to pay a separate rental fee, that could be negotiated in here as well, which would be beneficial to the composer because it means that they're sort of guaranteeing a certain number of additional performances. So it could work both ways. So that's just like the performance right and the right of being able to exclude others from having that right in the future. But then you get into the media rights, which are really adjacent to the performance right. And that's where we start to see, a couple different categories that we've tried to articulate here. The first is just the most basic audio recording rights. Does the commissioning ensemble have the right to capture the recording for archival purposes in an audio format? Can they use that for an AM/FM radio broadcast, locally? Could they even stream it on their website, through a webcast, or through the radio station's website if they have webcasting ability? So those would be some of the provisions that might be negotiated just for basic audio rights. Then you get into, okay, separate from that, we might look at, well, who has the right to commercially release that first recording of the work. And this becomes really important because for copyright purposes, the composer gets to decide who has the first commercial recording right. It's actually a right under copyright, or a provision under copyright, that a composer can decide, because once under Section 115, a work has been commercially recorded and released for the first time, anybody else can secure a mechanical license to record that work without having to necessarily obtain the composer's permission if they get a statutory license. So knowing who's going to give that first commercial recording is really important for purposes of who can record this work in the future. Separate, and again, apart from the audio recording rights, would be the audiovisual recording rights. In other words, the synchronization rights. So who has the ability to take a video capture of the performance and to put it up, for example, on YouTube or any other, audiovisual streaming service or mechanism. And so that would typically, we might see that contracted differently than just the audio rights. So we're hoping through the discussion guide just to be deliberate about saying, that audio rights are different from audiovisual rights, and let's just create a mechanism for that discussion to occur, including whether any of that material will be made available back to the composer for the composer's own promotional use, right? Because the composer may want to be able to feature these performances on their own website or in their own promotional materials, and obviously, subject to the terms of local collective bargaining agreements, composers are going to get, different responses as to how much material from the performance they can actually use for their own promotional purposes. So again, mostly just encouraging, discussion to occur around what the limitations are and what the types of media uses, audiovisual, would be available to a composer based on how the work is being digitized. So obviously, this could be a big part of the conversation, and just not just premiering and delivering the work, but in the afterlife of the work, how will other parties be able to hear the work if they want to rent it or perform it in the future? The digital uses actually become really quite important. So making some space for an audio perusal mechanism, through a password protected or some other website through which a composer could showcase their work, that's something that I'm hopeful might be encouraged as part of this anatomy of a commission process. Aside from that, I think we go into in the discussion guide, what we might consider to be the kind of ancillary wraparound activities. Once a composer and commissioner have committed to a project, how do you continue to enliven and breathe life into it to make it as vibrant a project as it can be, in the form of publicity and program notes and all the other elements that a composer's visit to participate in the premiere, educational and any other community events that might take place around a work, and sort of specifying and leaving space for that to occur within the conversation. One area that I've become particularly passionate about in thinking about composer agreements is this question of credit. In broad terms, compensation and credit are quite important to any party who's invested a great deal of time in creating a new work. And so what I'm curious about through this process is, can composers and commissioners give the kinds of credit to the composer in their marketing and promotional activities, so that for example, should the composer's name be listed alongside the other names of the other composers on the program or advertising materials, that credit, particularly for today's living composers, can be quite substantial. And so leaving space for the credit conversation to occur, and recognizing from the commissioner's perspective that the provision of credit is really quite important, and I think a really useful tool to encourage equity in the conversation beyond compensation, so that there's a feeling of shared investment in this work. I think nobody wants to sort of be involved in a project where they, open up the advertisement for, that upcoming program, and the composer who spent all the last 2 years working on this project, their name isn't even featured in the upcoming advertisement. So how can we encourage space for, for that to occur within the broader crediting conversation? And it is material, not just from a reputational perspective, but also from a legal perspective.